Let's shine some light on what's going on with Mahmoud Khalil, and this is from an immigration attorney who is itching for a case like this. So super quick recap. We are discussing a green card holder who attended Columbia University and was protesting the genocide going on in Palestine when ICE officers showed up to his university housing and detained him. Let's start where all immigration cases start, which is the NTA, which is the notice to appear in court. This is the charging document. This is what kickstarts the immigration court process. So these are the charges levied against them, and honestly, might as well have been written in crayon, which on the one hand, it's kind of refreshing to see that even though they knew the world's eyes would be on this case, they didn't give it any special treatment. It was still done in such a sloppy manner. But on the other hand, might be a little scary because it shows they really just don't care about standards or procedures. Looking through it, everything looks normal until we get to this part where they're saying that he got his lawful permanent resident status in November 2024 under Section 212A3C. No one gets a green card under that section. That is a section that states what a person is inadmissible for. So they're just flat out wrong. In fact, let me show you. Claiming he got his green card under foreign policy, that's never happened. They are claiming, though, is that the Secretary of State, little Marco Rubio, has determined that his presence or activities in the U.S. would have serious adverse foreign policy consequences. This right here is the formal charge. Did a criminal charge have to be brought up in order to revoke Mahmoud Khalil's green card? No, not necessarily. Immigration is primarily administrative and civil. It just has a lot of overlap with other areas of law like criminal law. The actual charge itself is something that 99% of people will never have to deal with, and 99% of immigration attorneys have never even seen before. And especially not in this context, because this is not how it's supposed to be used. This is something the government is weaponizing to try to stifle speech. This has never been used on a green card holder before, let alone someone that's just an ordinary citizen. Last time this was used was for a deputy attorney general over in Mexico who was here on a tourist visa, committed a crime, and there was an issue between the US and Mexico with regards to extradition laws. So that had actual foreign policy consequences because there would have been issues between the two countries. And it would have had a serious effect on the Mexican judicial system, which is why this was so important back then. But here, it's just being used on an everyday citizen using their right to free speech. And a lot of people may be saying that he is a green card holder, therefore he doesn't have the right to free speech. Yes, he absolutely does. He has the rights to the First Amendment. First Amendment applies to everyone. And there are very serious overlaps with free speech in this case. How do I think this case is going to go? Well, I don't have a crystal ball, so I honestly can't say. But, I have my predictions. I have pattern recognition. I see where this country is headed. So I'll write a quick synopsis in the caption, and then I will do a whole separate video on it. But I will say, though, that I do wish I had a case like this, not for the media attention that it's receiving, Lord no, but mostly for the implications that this is going to have on democracy, because as I mentioned, there are very serious First Amendment issues going on here. I don't exaggerate when I say this. This case has to fail, and the government has to lose this case in order for free speech to continue, because free speech is being weaponized. And what I said earlier about 99% of immigration attorneys having never seen this charge may not be true anymore if this case succeeds and it starts getting weaponized the way it has been already.